Hello, everybody, and welcome to our webinar presentation on Denied for Vocation Rehabilitation Services. What are your options to appeal? And this is presented by Disability Rights New Jersey, along with funding of the New Jersey State Bar Foundation. So just a little bit about me. My name is Jana Scheiman, and I am the managing attorney of the employment unit here at Disability Rights New Jersey. And a little bit about our organization. We are the designated protection and advocacy agency for the state of New Jersey. Each state has a designated protection and advocacy agency which receives federal funds for the purposes of investigating and monitoring facilities where individuals with developmental disabilities are located to ensure that you're not the subject of abuse and neglect. And we advocate for and help advance the human, civil, and legal rights of the residents of New Jersey with disabilities through various programs that we have. Right now, we are operating under the Client Assistance Program, which we will get into a little bit later. Client Assistance Program is a federally funded program designed to assist individuals seeking or receiving vocation rehabilitation or VR services who need some assistance. And in New Jersey, we have two VR agencies. We have the Division for the Blind and Visual, we have the Division of Vocation Rehabilitation Services and the Commission for the Blind and Visually Impaired. If you have any questions or any concerns about your rights to these VR services, or if you disagree with the service that they're saying you need or that you don't need, you can contact Disability Rights New Jersey and talk to us, and we'd be able to see if we're able to assist you by providing advice and counsel or by providing some limited representation. We'll cover that more at the very end of the presentation as well. A little bit about the New Jersey State Bar Foundation, who is funding today's presentation. Their purpose is to provide no-cost educational programs to help residents and individuals in New Jersey understand the laws. So their mission is to foster and increase awareness, appreciation, and knowledge of law and the legal systems among New Jersey residents, to serve as a statewide resource for law-related education to the public, provide opportunities for attorneys to serve the public through foundation programs, and foster professionalism and pride in the profession of law through public service. So we're going to have several learning objectives during the course of today's presentation. We're going to start with a brief overview of the vocation rehabilitation services. And part of this is going to be a very brief summary of those because we've previously done a three-part series on knowing your rights to VR services that has that explained more in full. We're also then going to talk about what do you do if a service is denied, a discussion about what the notice requirements for an adverse decision look like or what they should look like. Then we're going to walk you through the 4 levels of an appeal, whether that's an informal resolution, going to an administrative review, participating in a mediation, or going to a fair hearing. And then if there's any concerns that you have or any need to go past the fair hearing, we'll talk about briefly about further appeals and how the Client Assistance Program may be able to help. Please be on the watch for our scheduling because this, as we said, this is the webinar about the appeals. We previously have a 3-part series on to knowing your rights about the VR agencies, including what are the basis for VR services, how do you apply for VR services, and how do you seek tuition from the VR agency. We will be putting all 4 of these presentations together and doing one comprehensive webinar in April or May of this year. So please be on the lookout for that. So as we've spoken about before, we have the 2 VR services in the state of New Jersey, the Division of Vocation Rehabilitation Services and the Commission for the Blind and Visually Impaired. Both of these agencies are designed to provide financial sponsorship for higher education, including vocation training, certificate programs, community college, 4-year colleges, and universities. They're also able to provide job coaching services. They're able to provide you with assessments, assistive technology to be able to help you in the workplace. Now, there's 2 different ways of qualifying for the agencies based off of which agency you work with. With DVRS, you qualify for services if you have a physical, mental, cognitive, or other form of a disability, and you have a substantial impediment to employment that the VR services would be able to help you overcome. For CBVI, you are eligible for services if you are blind, visually impaired or are classified as deaf-blind, and you have a visual impairment that needs some additional vision-related services to make you eligible or to help you in the workplace, then you're eligible for services from the CBVI VR programs. The services for either agency must be individualized. So these are services that are consistent with you. What are your strengths? What are your resources? What do you want to do? And they are based off of, most importantly, informed choice. You must be able to exercise informed choice throughout the VR process. And this means you get to have a part in choosing your employment goal with the VR agency. You can't walk into the VR agency and say, I want to become an attorney. And they say, okay, we'll create an individualized plan of employment to make you a general construction worker. That's not consistent with what your goals are. But what they are supposed to do is sit and work with you to say, okay, where are your strengths? Where are your resources? So do you have, what is your educational background? What training are you going to need? Do we think that this could be a realistic goal for you? But you must be part of that conversation. They are not allowed to make that decision for you without your involvement. So once you've been found eligible for services and you've gone through and created an individualized plan of employment, or you're going through the application process and they're telling you, oh, you're not eligible for services because you're too disabled, or you're not able to receive services because you wouldn't benefit from our assistance. What do you do if a service is denied? So one of the things that we do want to make you aware of is there is a notice requirement that the VR agencies are supposed to adhere to. They must send a written notice when you apply for services and if you're being told that you don't qualify, or if you were previously receiving the services and are now being told that you no longer qualify for services. They could say that you no longer need their assistance or that you're now too disabled to receive their services. They must tell you this in writing. They're supposed to give you a written notice when you're developing an individualized plan of employment, and that will be a formal document that is prepared with the VR agency and given to you that contains essentially the contract of what services you're providing. They must give you written notice when your services are being changed, whether they're reducing services, changing you from a job coach to a long-term follow along, if they're sending you for an assessment. They must tell you this in writing and they must make that part of the individualized plan of employment. And you must also get a written notice when you're being referred to other agencies for assistance. But this is an ideal world. What must be included in the notice? They must tell you what service is being denied and why it's being denied. And it needs to provide you with the information that you need to appeal the decision. It must also provide you with the information for the client assistance program so that you can contact us to be able to say, I don't know what my rights are. I'm not sure what's going on. I want this service and they're telling me no. Can you help me? This is why I say this is part of an ideal world. In an ideal world, you will get a well-defined notice that has all of this information ready for you. But what's really happening? DVRS will routinely inform clients of case closures or denials of services or reductions of service through a telephone call, verbally at an IPE meeting, or in an email. These denials don't have any of the required information. They don't tell you why it's being denied. They don't tell you what the process is to appeal that decision or any information about how to contact the client assistance program if you would like someone to go over everything with you just to get a little bit more understanding or to potentially represent you in seeking the services that you are requesting. The CBVI notices that we have seen are more comprehensive and do typically provide proper notice to clients of how to appeal an adverse decision, whether that's starting at the administrative level within the office or whether it's going up through the chains. The CBVI notices, from our experience, have been more formulaic and do have the required information. One thing we absolutely want to note, and I will keep repeating this through the entire presentation because it's the basis of why we're here. You have the right to appeal a decision of the VR agency. Whether you've been given your appeal rights in writing or not, whether they told you, here's what you can do if you want review, here's the contact information for my supervisor, my manager, here's how you can seek a higher level of review. You have the right to request it. You have the right to review any decision that you do not agree with. And that's part of why we're doing this self-advocacy presentation, to be able to help educate you a little bit about what those rights are and what the levels of those appeals may be. So when you're appealing a decision, it's always recommended you start with an informal review. This is a review that you can request in writing. It can be a formal letter, it can be an email to your VR counselor. And it's just letting them know, I disagree with this decision. Can somebody else in your office review it? And this lets them know that you want that second pair of eyes. So then it goes to their supervisor and to the manager of the office. And they will review the decision and get back to you to say, yes, we agree, we need more information, or no, we don't agree, we are affirming the decision of the VR counselor. If you're not happy with the informal review, you can appeal it further. That's not you've gone to the supervisor, you've gone to the manager, and now you've reached the end of the line. You can appeal further, and there are 3 levels of appeal, which we're going to go over all of them in a little bit more detail, because each one has another layer of formality with them, just to make you aware and to give you a little bit of an ins and outs of what would happen with them. So there's the administrative review, a mediation, or you can request a fair hearing with the Office of Administrative Law. One thing we do note, even though we do say here that there are 3 levels of appeal, you're not required to go to an administrative review. You can go straight to a mediation or straight to a fair hearing without going to that administrative review from the internal appeal to the manager and the supervisor. So we're going to tell you about all 3 of the options just for your information. But again, you don't need to follow them exactly in this order. So an administrative review. This is a review by a panel of VR agency staff and really is the least formal of the appeal options. This is a request in writing to your VR office and to your VR counselor in letter format, which can be sent via regular mail or email, asking for an administrative review. Just a moment. And once you've requested that administrative review, your VR counselor in the VR office should be reaching out to schedule the meeting with you within 14 days of receiving your request. And this will be to set up a time and a location, because there could be several people who will be part of the review. And so they need to make sure they have the space for it. And is it a place that everybody can get to? Are you able to get to the VR office? Is it going to be virtual because you're not able to physically get in? So this will be why they're going to be reaching out to try and schedule the meeting. Now, I do want you to know you're able to bring other people with you to the administrative review if you think that they would be able to assist you while you are there. Typically, this will be attended from the VR side by your VR counselor, their supervisor, the office manager, and the field chief that oversees that office. So that way you'll have at least 4 members of the VR staff in the room with you to discuss and go over your request. Typically, they're held in one of the VR agency offices in a conference room that is large enough to accommodate everyone safely. We do say the accommodate everyone safely just because we are in that post-COVID world where it's still around, but we're not taking as many precautions. However, there still may be that need for a little bit of distance between you and the next person. So this is an opportunity for both you and the VR office to discuss the concerns and the services in question, and to really have a conversation about whether or not it is appropriate. You will have the opportunity at this administrative review to present your arguments for why you feel the services are necessary and are appropriate for you, and why they should be provided. The VR agency will also then have the opportunity to say, this is why we think that it's not appropriate. This is why we think it should be reduced. And so it's part of that conversation back and forth. The VR staff will be able to ask questions and to review any documents that you provide, and you'd have the opportunity to review any documents that they provide as well. This is where if you have someone who's coming to present with you or to speak on your behalf about why this service would be beneficial for you, they'd be part of that conversation as well to be able to say, based on my experience, here's what would be beneficial for this person. This is why we think it would be effective. Here's why they need that job coach service. Here's why they need that assistive technology assessment. And the VR agency would be able to question them and have them as part of the conversation to be able to get the full picture of what you're looking for. After the administrative review, it is important to note you are not going to get a decision right then and there. There are different policies and processes for each of the agencies. They're kind of similar, but a little bit different, which is why we're going to talk about both of them. With DVRS, the staff will need to review their notes and the documents that you provided to them, and then they will send a written recommendation to the assistant executive director and executive director for their review. With CBVI, an initial finding will be drafted by the panel who oversaw the administrative review and send it to the executive director for review. Both agencies will then send you a written final decision from the executive director that either agrees with the recommendations from the staff or disagrees with the recommendations from the staff based off of the documents and the notes that they have from the administrative review. So what happens then if you don't like the administrative review decision? Again, this isn't the end of the line. This is also, you don't have to go to the administrative review. You can go straight to a mediation. A mediation is a slightly more formal proceeding where instead of presenting before a panel of individuals from the vocational rehabilitation agencies, you're presenting to a mediator who is appointed to listen to both sides to try and reach a resolution. The mediator is an independent third party, meaning they don't work for VR agency, they don't work for you. And they are impartial and unbiased when they're looking at the question that is presented before them. And you're able to request the mediation. It is a voluntary option. So you can say, I would like a mediation, and the VR agency could turn around and say, no, we're not going forward to a mediation. Part of this may be that right now, while this is an option available to you, there is a lack of mediators in the state of New Jersey that the VR agencies are able to work with. So this typically is not an option that is seen that frequently, but we are telling it to you because it is an option available to you that could be agreed upon. So to request a mediation, you must request the mediation in writing. This is a formal letter that gets sent to the agency. And I'm going to leave this slide up for just a quick moment for you to take down the information. It's also going to be part of our self-advocacy guide that we will be posting on our website after this presentation is done. So I'm just going to hold here for about 15-20 seconds to let you take a screenshot of this information. Okay. What happens after you've requested the mediation? Once the mediation has been agreed to by both you and the VR agency, the VR agency will retain a mediator within 30 days of the written request. If they're unable to identify or secure a mediator, the VR agency must provide you with written notice within 30 days of your initial request, which will allow you to then file for a fair hearing as needed to seek a review of the decision. You can also go back to an administrative review, but typically after you're at the mediation stage, the next phase will be the impartial fair hearing. And once the mediator has been appointed, the mediation must be scheduled within 20 days of a mediator being appointed. So here you're looking at, there could be the 30 days to retain the mediator, and then 20 days to be able to have the actual mediation. So you're talking 50 days from the date that you put in your request. That can be extended with written consent by you and the VR agency, but that's the typical timeline that you are looking at. So what happens at a mediation? It is a more formal procedure and is typically held at the office of the mediator or at a location of the mediator's choosing. Why is this important? Because then you're not at the VR agency's office and surrounded by the VR agency personnel, and it's not at your office or at a place of your choosing. It is somewhere that the mediator has selected that they have control over. You and the VR agency will start in the same room for the proceeding, and you will each give a brief introduction as to why you're here, what your position is, and how you think it should be resolved. Then the mediator will separate you into two different rooms, and the mediator will then move between the rooms throughout the proceeding. The mediator will be trying to get everybody to come to an agreement. So the mediator will be going back and forth between the various offices where you'll be sitting and the VR agency will be sitting to say they're talking about they want to become a lawyer. So they would like to have funding for undergraduate degree and law school. DVR comes back and says, based off of their testing, we don't think that they would be able to pass the bar exam. We do not think they'd be able to score high enough on the LSAT, which is the test needed to go into law school in the first place. And the mediator would go back and forth and bring that information to both parties to try and say, here's what we're trying to do. Can we reach a resolution rather than go for law school right now? Do you want to go for a paralegal certificate? Do you want to have an internship at a law firm to see if this is an area you would like to go into? And that's all part of what the mediator's job would be trying to do. If you reach an agreement with the VR agency at this mediation, a formal agreement would be written up and then signed by both you and the VR agency. If you do not reach an agreement, then there is no written decision that is to be drafted. And the mediator would then just write up a statement saying that the parties were not able to reach a resolution, and you have the right then to seek the fair hearing. If you do reach an agreement and you do have that mediation written up, that will essentially act as the contract to say what services the VR agency will provide and what you've agreed to receive from them. So it will also then be incorporated into a new individualized plan of employment to be able to set up to start the services for you to go forward and reach your career goal, to have the assistance at work. But that's part of what everybody has agreed to. So what happens if you don't reach an agreement or if there is no mediation? Then you're going to the most formal of the appeal options, which is the impartial fair hearing. And this must be requested in writing in a formal letter sent to the VR agency. Now, one thing I do want to note is the letter doesn't have to say every single thing that you disagree with. It can be very, very short. Your request to the VR agency can say, I disagree with the decision of the VR agency regarding tuition services from January 1st, 2024, and request that this be referred to the Office of Administrative Law as a contested matter. One sentence, and that is enough for them to then transfer the file over to the impartial fair hearing office at the Office of Administrative Law. So you do not need to go through everything in writing. You don't need to put every concern that you have in your written request. I know that this is kind of contrary to what we might think about in most law, because normally with a complaint, you have to put every single thing that you would like to complain about into that initial filing. This is very different with the administrative proceeding because part of what's going to be sent over to the Office of Administrative Law will be the entire record from before your request, which includes your case file and any written notices or any correspondence and communication you've had with them, such as your request for the administrative review, anything that was sent to the mediator. That will all go over to the impartial hearing office. Once again, this must be requested in writing. This is a formal letter sent to the various agencies. This is the same address that we had put up before. I'm just going to pause here again for 15 seconds in case you didn't take it down before, because this is where you will be sending these requests. Okay. So once you are at the impartial fair hearing, the administrative law judge will be assigned. And one thing we do want to note, just so you are aware of it, where before you've been dealing with the VR agency, you've been dealing with your counselor, you've been dealing with the manager or supervisor at the office. Once you get to the Office of Administrative Law, you will now be dealing with a member of the Attorney General's office, because the VR agency will then be represented by counsel, which in the state of New Jersey is the Office of the Attorney General. So any inquiries or letters or correspondence will need to go to that attorney rather than to your agency directly. The judge's clerk, once all the parties have been assigned, will reach out to schedule an initial conference with you. And this is one point I do want to stress. And before we go any further with the impartial hearing information, I do want to make sure that we get out there. While you are able to represent yourself at a fair hearing, it is strongly encouraged that you seek representation of an attorney or an advocate, such as the Client Assistance Program. Again, this is a more formal proceeding. It's not quite as formal as going to the state superior court, the appellate division, or the state Supreme Court, but there are various rules and regulations that do have to be followed. The courts will be expecting things to be in a certain behavior, certain manner, certain formality, that having that attorney or advocate could really help you at this point. Again, you have the option to be your own self-advocate, but it is strongly encouraged that you do seek representation of an attorney or an advocate when you reach this level. So with the fair hearing, your first meeting with the court will be a status conference, and this is usually held over the phone. And it's just for the court to be able to speak with the parties and say, do we think there's a chance this could settle? Do we think there's going to be an option that this could resolve before we go to the hearing? Do we think that there's going to need to be the exchange of discovery? And discovery is a request for any written documents that you think could be able to assist you with your proceeding. If you think that there's something with the way that the VR agency has created a policy, you can request information regarding how that was formed, who they spoke to, what information they collected, to be able to see what their process was, and that may wind up hurting or helping your case going forward. If you do say you want to have discovery, the court will set a schedule for that discovery to occur. Or if you're saying we don't need any discovery, we're ready to just go forward to a hearing, Your Honor, they will set the case for a date for your initial trial. And this is the opportunity for both parties. This initial conference is the opportunity for both parties to really impress to the judge, why are we here? What are we searching for? So when you go to a fair hearing, you've gone through a discovery process, you're at the impartial hearing, and you're ready to go before the judge. That is one key difference with the impartial fair hearing process than you would normally see on a court proceeding on TV. Here, the fair hearings are heard by the judge. There is no jury in the administrative process, so your entire presentation is to that one judge. The judge will then hear brief opening statements from the parties. That's for both you and the VR agency. And after you've done the opening statements, you'll each present your case. And this is where you will talk about why you think that the service that you're requesting is appropriate. So say, for example, we're talking about tuition. You're saying you want to become a teacher and you need to go to your undergraduate degree and get your master's degree. You can speak about with yourself about why you want to become a teacher, what the process is to become a teacher, what the steps are. You can bring in somebody from a college to be able to talk about, here's the certification requirements, here's the education requirements. So you can bring in anybody that you would let the court know about and get them to agree to let you bring in to be able to help you support your case. Part of why I say let you bring them in, you will need to notify the judge and your opposing counsel or the opposing party who you would like to bring as your potential witnesses and what you think that they're going to be able to present. So you can't bring 10 witnesses who are all going to say the exact same thing. The judge may say, okay, I see this list. I see the testimony you want them each to have, but I'm only going to let you bring 2 people. So tell me who the 2 people are that you're going to bring. But that will all come from the judge. So that's not something that we can really say, here's what will happen, because every judge in the administrative law has their own process and has their own procedures. After the impartial hearing office, I know we're not quite done yet. I'm sorry. The court will ask you and the VR agency if you would like to make any closing statements. And this could be either at the hearing or you could do them as written summations of your arguments. Typically, the Attorney General's office, who will be representing the VR agency, will ask to be able to make the statements in writing after the hearing date. So once the court has received the closing statements, whether these are the day of the hearing or whether they're in writing a week, 2 weeks, 30 days after the hearing, the court will then close the record. Once that record has been closed, the court has 30 days to issue a decision. However, I do want to note they can then also grant themselves an additional 30 days as needed to be able to file that decision. So that 30 days can really be seen as 60 days. If they need any time after that 60 days, they don't ask you or the VR agency. They make the request themselves to the Office of Administrative Law, who then tells them yes or no to be able to get that extension. You will get copies of any notices or any extensions to tell you when to expect that decision. But wait, there's more. After the fair hearing, once the judge has issued a decision, if you get a decision in your favor, you can go out and celebrate, right? Unfortunately, that is not a final decision. Whether it is in your favor or it is in the favor of the VR agency, the judge's decision from the fair hearing is not a final decision. It must be sent to the agency, which for DVRS is the Department of Labor and Workforce Development, and for CBVI is the Department of Human Services. And the decision will then be reviewed by the director of either of those agencies. The director of the agency will then issue what is called a final agency decision, which becomes the final word of the administrative law appeal. And the final agency decision can say, yes, we agree with Your Honor. This is a very well-reasoned decision. We agree with this, and we are going to uphold this. They could say, we agree with some of this, we disagree with some of it, so we're going to modify the decision. Or they can look at it and say, what is this judge doing? This isn't any of our policies. We're going to overturn this decision. The final agency decision, however, is not the final decision of the case. If you disagree with the final agency decision, there are additional options to appeal, which do involve going to the New Jersey state courts and going to the appellate division. However, when you are going to the state appellate division, it is highly, highly recommended that you have legal counsel working with you on any subsequent appeals if you have not already brought one on. The reason for this is the appellate division is very, very formal and has very strict regulations and requirements as to who can appear before them. You can appear pro se, which means to represent yourself. The concern would be that it would put you at a disadvantage to go through the appellate division. So that is why we're saying if you have any questions or if you get to this decision, please recommend that you do have a consultation or speak with an attorney, whether it's a client assistance program or a private attorney, to be able to assist you on this. The client assistance program throughout this entire process is here to help you. As a VR applicant, you have the right to contact the client assistance program at any step of this process. We are here to help answer your questions, provide you advice and counsel to help understand your rights, And we may be able to provide legal advocacy all at no cost to you through the process. So please, if you have any questions, if you're applying for services, if you just want someone to help walk you through the the policy of the process, or what services do you think you could ask for, contact the Client Assistance Program. We're here to help you. And just a little bit about us, we have 4 different levels that we provide assistance with. We can give advice and counsel for if you're looking to receive services available under the Rehab Act of 1973, as amended by the Workforce Innovation Opportunities Act and Title I of the Americans with Disabilities Act of 1990. We're able to provide advocate and individual representation for to help ensure that your rights are being protected and that you're receiving them under the Rehabilitation Act. We're also able to provide information to you about protections that you may have under Title I of the ADA, which does cover employment. And we also do provide systemic activity services where we advise state VR agencies and other rehabilitation agencies, including the state rehabilitation councils and state independent living councils, about problem areas in delivery of VR services to help suggest and advocate for methods of improving agency performance for the end result of making sure there are services available and in place to be able to assist you as the applicant. And with that, we will turn it over to any questions. And there are a few that have been put into the chat. And one question I have is, what do I do at an informal review? The first thing that you do is that just you're letting the VR agency know that I have a question about my services. I object with the denial, and you're having a conversation with them. You're putting out the here's why I want this service, here's why I think it would be beneficial for me, and why I think that I need this service. So at the informal review, if we're talking just the initial phase, that's just the correspondence and going back and forth with your counselor, their supervisor, their manager to be able to just say, hey, here's the service that I'm looking for. Here's why I need it. Why are you guys saying that I don't need it? Let's have that conversation. The next question I have is, how is an administrative review different from an informal review if both are just with the DVR staff? Can I go straight to mediation after an informal review so someone neutral can be there? Okay, we're going to break this into 2 different segments. The difference between the administrative review and the informal review is how you receive a final decision. With the informal review, it's just that very informal process where you're talking with the VR counselor, you're talking with their manager, and you're probably going to get either a letter or an email that says, "We disagree with your request." Whether you're saying, "I'm looking for tuition services, we decline to provide tuition services. We don't think it's a necessary support for you to receive assistive technology at this time." The administrative review has a little extra layer of formality where it's going before the executive director and you're getting an official agency decision as opposed to an office decision. So that's the key way of looking at the informal review versus the administrative review. The informal review is office specific because that's the VR counselor, it's the supervisor, the manager of that office, and the field chief of that office. With the administrative review, you are getting a decision from the executive director of the entire agency. So it is an agency decision. You do not have to go through the administrative review process. You can go straight from the informal decision from that office review and request a mediation. Now, again, with the mediation, I do want to note that the VR agency could say, we're not going to mediation. And right now, they typically don't because they don't have enough mediators available. But you are able to seek that straight from that informal review. You do not need to go through the administrative review. That's just an extra. I want to try and resolve this without going into a court system or going into that more formalized setting. So that is an option for you, which is why we went over it today. The next question we have is, does the appeals process take a long time? That depends on the level that you're at. If you're talking an administrative review, you typically are able to have a decision within 60 to 90 days of requesting the decision. So they have 30 days to request the review, set up the review, and have the administrative review. and then they have 30 days to issue the decision. If you're talking a mediation, that's more of a quick turnaround time because again, they have 30 days to to appoint the mediator, and then the mediation must occur within 20 days of that appointment. So you're at a 50-day timeline from when you've requested to having the actual mediation. Whether you're going to come up with a solution there or not is that I'm not able to tell you, but there have been cases in mediations that I've done where we've had to go back for a second or third day because the parties were interested in trying to reach a resolution and they thought that they were close. When you go to the impartial hearing decision, a lot of that can depend on the individual judge. I've had some cases in the impartial hearing office that we've been in the discovery phase for over a year. So the case was filed in, say, November of 2021, and it settled in April of 2023. I have another case that we filed in August of 2020 and 2023 that is looking to go to fair hearing in March of 2024. So it all depends on the judge and what level of discovery that you need. It can be a lengthy process, especially now that a lot of the administrative reviews or the administrative law cases are no longer held online. They're being held in person. So that does create more of a wait to be able to make sure that the judges are available for the length of time that you need. So I wish I could say that an appeal is a quick process. I can't. I can say that sometimes you can have it where you file your initial request and you're going to a fair hearing in 90 days. You can also have situations where you file your request for the fair hearing and you're going to a hearing in 2 years, 3 years. It all depends on the individual facts of the case and whether or not there's a discovery and whether there is the availability of the judge who was assigned. So the next question I have is, if DVRS denies my request at the informal review level of appeal, should I ask for that decision in writing? Absolutely. Any decision from the VR agency, if they're denying services, if they're reducing services, or if they're saying that you don't qualify for something, they need to send that to you in writing. And if they tell you over the phone, oh, we're not going to provide that service, can you send me a letter that says that? Can you send me an email that says that? Can you let me know what the next steps are? Those are all things that you can say to ask them to put it in writing. One of the reasons that we do suggest that you get that in writing, say they tell you over the phone, we're not providing this service. And then you go to an administrative review and they say, oh, we never told him that. It's not in our case notes and there's no email to it. We're not sure where they're getting that from. So always follow up. If they're telling you something verbally, ask for it in writing. Ask for it in whether it's as informal as the email, or as formal as the letter, or to have them put it in your IPE, but try to get that in writing. The next I get is, what steps can I take if I don't receive written notice from DVRS if they close my case or change my services? This is a odd one because this is one that we do hear and we do see quite a lot. And the first thing I would say is you can follow up with your VR agency. If we're talking that you don't receive notice that they've closed your case, if you know who your VR counselor is that is assigned, I would recommend that you follow up with them. Say you've put in your application. When you have your application in, they have 60 days to make a determination about whether you're eligible for services. If you haven't heard anything by day 45, just do a follow up. If you don't hear anything by day 55, do another follow up. If they haven't responded to you by then, send a message to them on day 59, not just them, but find out who their manager is and their supervisor and include them on the email, include them on the phone call, just to make sure that you're saying, I'm still here. I'm still looking for services. I would like this information. Please let me know what's going on. That creates that trail on your end. And if they're still not responding to you, call the client assistance program because we're able to assist you. And at that point, we can go to the VR agency and say, hey, they've applied for services. They're not getting a response. Can you let us know what's going on? Then we can try to intervene and see if your case has been closed. If your case has been closed, why was it closed? Can we get it reopened? Can we help you get that eligibility assessment? So you can always just keep pestering the VR counselor. I know it probably sounds a little bit like you're nudging them or you're nagging them, nag them, because sometimes they may not respond because they do have a number of clients that they're working on. So things can fall through the cracks that if you keep responding, you keep emailing them, keep messaging them, that's more likely to be able to say, "Oh, I need to make a decision on this. I need to let them know about this." So just keep responding to your VR counselor, keep calling, keep emailing them. If they're changing your services, one of the ways that you're going to find out whether they've sent that notice in writing is suddenly your job coach isn't going to be showing up anymore. Or they're going to say, "Oh, we're not providing this assistive technology." You go to talk to the assistive technology provider and they say, "Well, we never got that authorization." Then you can go back to your VR counselor via email or phone call to say, "Can you please let me know what's going on?" So if they notice that there's that change in services or a provider is no longer showing up, you can reach out to your VR counselor to be, "Hey, what's going on here? Why aren't they showing up anymore? Can we have a conversation? Can we meet about this?" So I hope that helps a little bit. And the last question that I have is, how can I contact the CAP program to request assistance? Okay, we have multiple ways of reaching us. Right now, we have up on our screen is our organization website, disabilityrightsnj.org, as well as our different social medias that we are able to, you can reach out to us at for assistance and information. We also have our contact information. We are on 210 South Broad Street, third floor in Trenton, New Jersey. And in the state of New Jersey, we can be reached at 1-800-922-7233. And we can also be reached at advocate@disabilityrightsnj.org. So that's multiple ways of being able to reach us. First, our physical address and our phone number and our email, and then also our social media platforms to be able to connect with us and get connected to the right department. Are there any further questions? Seeing none, I would like to thank you all for being here as part of our presentation. And again, keep watch in April or May. We will be doing another presentation that will have everything in it of how do you apply for VR services? How do you request an IPE to be developed? And if you're not happy with the services that you're receiving or the services that you're being granted, how do you appeal that decision? So keep watch for that. Thank you guys all for being here, and I hope you have a great day.